Uh, Justice means to give each and every person what they deserve. Justice means the standard of righteousness. By standard of rightfulness, one means to say that minimum threshold should be applicable of what will amount to right or wrong. Justice traditionally means ensuring that fair results are produced and each person duly receives what he is entitled to. The framers of Indian Constitution were aware about the need of establishing justice in his country. Therefore, they made sure that it is included in the Indian Constitution.
Justice is not a cloistered virtue. She must be made to suffer, though unpalatable and outspoken, but respectful scrutiny of even the ordinary man. I think we can look at the concept of justice from the point of view of the preamble of the Constitution of India. The preamble of the Constitution of India talks about and is the entry door, as it were, to the values for which this country has been constituted into a republic.
Today, we all have gathered here to celebrate Constitution Day. Constitution Day, also known as Samvidhan Divas, is celebrated in our country on 26th November every year to commemorate the adoption of the Constitution of India. On 26th November 1949, the Constituent Assembly of India adopted the Constitution of India, which came into effect from 26th January 1950. When the Constitution was adopted in the year 1949, there were no provisions regarding the fundamental duties to the citizens, though there was a Part 3 for the fundamental rights. The fundamental duties of citizens were added to the Constitution by the 42nd Amendment in the 1976 upon the recommendations of the Swaran Singh Committee that was constituted by the government. The fundamental duties are essentially taken from the Indian tradition, mythology, religion, practices. Essentially, these were the duties that are the codification of the tasks integral to the Indian way of life. I am honored to introduce our guest of honor for today's function, Mr. Guru Krishna Kumar, Senior Advocate, Supreme Court of India. Mr. Guru Krishna Kumar graduated in law from the University of Madras with a university rank. Even while in college, he was an active debater and won prestigious debates at the state and the national level. He represented India in the prestigious Philip C. Jessup International Moot Court Competition in Washington, D.C. and finished in the top 8 teams of the world. He was selected by the British Foreign and Commonwealth Office under the British Chevening Scholarship Programme for pursuing a course in commercial and corporate law in the UK. This program involved an academic phase and a practical phase where he worked in a law firm and barrister's chamber in London. He began his career as a legal resource in Larsen & Toubro Limited, one of India's leading corporate houses. He resigned from the assignment after taking a brief stint to take up full-time litigation work, initially in the Madras High Court, and thereafter he moved to the Supreme Court of India. In 2012, he was designated as a senior advocate by the Supreme Court of India. He has extensive experience of over 3 decades now in handling disputes and appearing in important cases in various fields of law, like constitutional law, commercial and corporate laws, including intellectual property law, arbitration law, insolvency and bankruptcy law, election disputes, etc. He also served as an additional Advocate General of a state government in the Supreme Court of India. He has appeared pro bono in cases involving issues of significant social implications. His work experience outside India includes appearances in international commercial arbitrations, participation in proceedings in the UK cases involving private international law issues to assist in providing expert evidence on international Indian law. I would request Mr. Guru Krishna Kumar, Senior Advocate, to kindly enlighten us on today's topic.
My humble greetings to this distinguished gathering, consisting of Justice RITURAJ AWASTHI, Chairperson of the Law Commission of India, Justice Narasimha Reddy, the members of the Law Commission who are present here, my good friends, senior advocates, colleagues at the bar. The topic for today, idea of justice after 75 years of independence, is at once very interesting and at the same time intriguing. And the reason why I say is this. At first blush, somebody would think, justice is justice. What is it that it can change to? Can there be a reinvention or a recalibration of the idea of justice because of passage of time? This is something which makes it very intriguing. That's the reason why I said it's very interesting and intriguing. The moment somebody talks of justice, I'm reminded of this very curious anecdote which Justice Krishna very felicitously gave in one of his works from, if I remember, Greek or Roman mythology. There was this king who was supposed to be very just. He had in front of him a person who was accused of killing another person. So this accused was convicted to death for committing the offense of murder. He was placed before the hangman, and just before he was being executed, it came to light that the person whom he had killed had in fact not died, and he was very much alive. So it became a very paradoxical and ironical situation. The executioner said, no, I cannot now execute this man because the offense for which he is supposed to have been convicted is not now committed. It became a big predicament, so everyone went before the king and asked the king what is to be done. The king said, I will do justice. And how? He said, all the three will be executed. And the reasoning given by the king was very, very striking. The person who had originally been convicted, the king said, has already suffered a conviction, so he has to be executed. The person who did not carry out the execution, he said he had to be hanged because he refused to carry out lawful orders. And the third person, the person who in fact was alive and had not died, the king said he is supposed to have died long back, so let him also be hanged. I mean, this is the kind of notion of justice which was prevailing when we had a tooth for a tooth and an eye for an eye. In that sense, the idea of justice has moved on. Of course, talking of justice as a pure theoretical formulation, we have so many theories floating around. We have corrective versus distributive justice, procedural versus substantive justice. We have ideal versus conservative justice. Every second day, we talk of how whether an action of a person is just, whether a law which has been enacted is just, or whether a policy which has been introduced by the state is just or not. That way, these theoretical formulations can abound. They can go on. But I think what is important to be noted is that justice is not a cloistered virtue. I'm reminded of this statement, famous statement of Lord Justice Atkin, though said in a totally different context. While dealing with contempt law, he said justice is not a cloistered virtue. She must be made to suffer, though unpalatable and outspoken, but respectful scrutiny of even the ordinary man. And another very famous approach to justice, to the idea of justice, is what that famous jurist John Rawls said. Justice is the first virtue and priority of any social institution. So that way, your theoretical formulations and approaches to justice can really be multifarious. They can be multitudinous. And I dare say, we may end up getting caught up in a vortex, as it were, of theoretical formulations. But I think to contextualize the topic for the occasion for which we have met, being the Constitution Day, I think we can look at the concept of justice from the point of view of the preamble of the Constitution of India. The preamble of the Constitution of India talks about and is the entry door, as it were, to the values for which this country has been constituted into a republic. You look at the preamble, the very first part of the Constitution, it starts with how it wants to secure for the people of India justice. The first value, therefore, that is sought to be secured for the public, for the citizenry of the country, is justice. It talks of how justice, being social justice, economic justice, and political justice, have to be secured to the citizens. Of course, it goes on to talk about liberty. It goes on to talk about thereafter equality and about fraternity. In that sense, justice is the first and foremost value, ideal, and object of the Constitution itself. This is not to take away from all the other three. In fact, in my view, there cannot really be a gradation. One leads to the other. So to that extent, what needs to be understood is justice is something which we the people have given to ourselves so that the country will be able to progress into a healthy democracy. Now, the idea of justice, it has undergone so many changes. Let's take, for example, the right to life under Article 21. Article 21 providing that right to life and liberty shall be made available to all citizens except in accordance with procedure established by law. Now you go back to Gopalan days, A.K. Gopalan's case. The Supreme Court said procedure established by law is not really due process of law as what is laid down by the American Constitution, under the American Constitution or by the American courts, but some procedure established by law. That law need not be just fair or reasonable. Now, starting from that formulation, we moved on over decades and came to Maneka in 78, where the Supreme Court said the procedure established by law is not something which can just be a mere procedure which is available on paper, but must be just fair and reasonable. Now, I'm citing this example only to show how in the realm of civil rights and political rights, the court said idea of justice is something where you must have justness. You must have reasonableness. You must have fairness. This is, of course, in continuation of the large and expansive meaning that has been attributed to the meaning of life itself under 21. So many rights have been built into it. Olga Tellis said, right to life is not mere animal existence. Like that, we have had a number of rights have been read into 21. We have culminating ultimately in that judgment of right to privacy in 2017. So here, what I want to underscore is the fact that the idea of justice has permeated the approach to be adopted to the letter of the law or the letter of the Constitution to infuse life into it. So this is something which I thought must be flagged and understood. And it is really in this context, I think, the meaning of justice has to undergo changes from time to time. What was just or fair, maybe 10 years back or 2 decades back, will no longer be just and fair, given the change in the social milieu. We are talking of how the Constitution is not a mere document which is composed of certain articles. It is an organic document. It has to change with time. Please remember what the Supreme Court had to say in Keshwananda Bharati's case. It is not something which is like an edict written on stone. The provisions of the Constitution will have to be understood in the context of the times in which we live and consistent with the goals of the preamble, which start with the idea of justice. Now, moving on, I can think of a few other examples. Please look at the recent amendment to the Constitution, being the 103rd amendment to the Constitution, by which reservation of 10% has been provided for the economically weaker sections. Now this amendment was put to challenge, as everybody knows, and recently, last month, the provision has been upheld. Now what was the approach, broad approach adopted by the court? The court said any affirmative action which is made available by the state will have to further individual justice. The traditional paradigm of reservation being made available only for socially and educationally backward classes is something which cannot be the only basis on which the validity of state action for reservation should be tested. Because the argument against the validity of the amendment was that the Constitution provides that only socially and educationally backward classes can be provided reservation. And that reservation is provided on the basis of caste. So the argument was the Constitution providing only this form of reservation, the provision of reservation on the grounds of economic impoverishment is something which cannot be accepted under the constitutional scheme. The Supreme Court said no, it can't be. And what is interesting is this. As everybody would be aware, it was a majority judgment of 3:2. But even the minority decision accepted in principle the position that provision of reservation for economically weaker sections cannot be said to offend the basic structure of the Constitution. Therefore, the point to be noted here is the approach taken by the court was the preambular provision of economic and social justice, where it said economic deprivation would definitely result in the person not being able to realize his goals. Therefore, the court said 103rd Amendment to the Constitution has to be accepted to be a valid provision under the constitutional scheme. We can look at various other recent judgments. Please look at the judgment outlawing triple talaq, or for that matter the judgment decriminalizing homosexuality, or even for that matter the judgment immediately following that, where the provision for adultery was held to be invalid in the Indian Penal Code. Now, all these are instances where the idea and notions of justice have undergone transformation consistent with the times. That's really the point that I want to make. Therefore, when we talk of justice or the idea of justice after 75 years of independence, I think we are looking at justice, a just system, a justice dispensation system, and a legal system which is modern and consistent with the times. Today, we are talking of transformative constitutionalism. That is something which again is no more than an embodiment of the idea of justice moving with the times. You talk of constitutional morality, you talk of transformative constitutionalism. These are all nothing but reflections and expressions of the same idea of justice being rendered consistent with the social milieu and the times in which we live. This is not to say that justice is ephemeral. The idea of justness, of being right, is something which transcends this, but then it has to be contextualized for the times in which we live. The other day, all of you would have seen, the Supreme Court has come up with this new proposal or idea of a hackathon, where suggestions have been invited from the public as to how best or how better cases can be registered and listed before the Supreme Court in the fastest and the most efficient possible time. Now what does this reflect? This talks of how justice dispensation has to become litigant-centric. At the end of the day, the justice delivery system is not in existence for the judges and the lawyers. It is for the purpose of dispensation of justice for the litigant. Now, I think therefore the idea of something like a hackathon, where the court wants to look at how imagination of the common man can be kindled, and they come up with some ideas, imaginative approaches. Those can be considered and incorporated in an otherwise traditional approach. Therefore, this is again an idea of how you look at justice, but look at it as the country moves on towards the next century and millennium. Therefore, This is the reflection which I think we should be looking at, and I thought perhaps there may not be a more appropriate occasion than to flag another issue which I thought can be ideally done and appropriately done with the presence of the chairman of the Law Commission and all the other members of the Law Commission. The preamble, I think Indira Sani said, really reflects the aspirations which are contained in Part 4 of the Constitution. All the directive principles of state policy. I would think that if we are looking at justice or the idea of justice after 70 years of independence, perhaps we would be more appropriately justified in looking at what the directive principles are which we still not have given expression to. Are we looking at a uniform law for all communities? Are we looking at further measures to ensure that steps are taken for ameliorating the poverty of various sections of society? These are all various aspects which are finding place in the directive principles of state policy. I think the fact that we are celebrating 75 years of independence, if we have to look at the idea of justice at this juncture, we really look at how we can further and give effect to many of these directive principles of state policy which still stand unrealized. I remember that there is still a petition which is pending in Supreme Court as to how fundamental duties can be brought into effect and how much they can be enforced. This is another example of what approach can be taken towards the idea of justice at 75 years of Indian independence. So with these thoughts, I thought I'd leave you with some reflections and hope that 5 years down the line or 10 years down the line, we still have a better idea of justice after 80 or 85 years of independence. Thank you for the opportunity.
Thank you, sir, for the valuable insight. Now, I am privileged to introduce Chief Guest, Honorable Mr. Justice RITURAJ AWASTHI, Chairperson, Law Commission of India. Honorable Mr. RITURAJ AWASTHI graduated in law from Lucknow University in the year 1986 and enrolled as an advocate on 1st February 1987. He practiced in civil service, educational matters and at Lucknow Bench, Allahabad High Court, and was appointed as the Assistant Solicitor General of India for the Allahabad High Court in the year 2007. After practicing for more than 20 years, he was elevated as an additional judge on 13th April 2009 and took oath as permanent judge on 24th December 2010. Honorable Justice Awasthi was also mentioned as a senior judge at the High Court at Lucknow in the year 2021 and thereafter was elevated as Chief Justice of Karnataka High Court on 11th October 2021. During his tenure as a judge for more than 13 years, Honorable Justice Awasthi decided approximately 44,000 cases, out of which more than 600 judgments were approved for reporting. Most of the cases decided by Honorable Justice Awasthi had a nationwide impact as well as international importance too. Justice Awasthi presided over the matters related to NRHM, Sahara Sebi's case, reservation and promotion case, CBI inquiry in CMO murder case, etc. Justice Awasthi also issued directions for the cleaning and the preservation of River Ganga in the Namami Gange case at Allahabad High Court, which had a far-reaching impact on the revival of the sacred river and making it polluting-free. Justice Awasthi, while holding the post of Chief Justice of Karnataka, decided various full bench cases, including those of income tax matters and National Investigating Agency cases, mines and mineral, and also wearing of hijabs in school cases. Justice Awasthi also decided other landmark cases like online gaming case, issue of legacy waste in Mangalore, appointment of public prosecutors, and important arbitration cases as well. Justice Awasthi had a remarkable contribution to field of law which had far-reaching impact. The Government of India had appointed Justice Awasthi as the chairperson of the 22nd Law Commission of India on 9th November 2022, and the Law Commission of India will consider and submit his report on various crucial aspects under his leadership and guidance. I now request Honorable Mr. Justice RITURAJ AWASTHI to kindly enlighten us on today's topic.
topic, the idea of justice after 75 years of independence, I feel that Mr. Guru Kumar, as senior advocate, has very aptly and properly introduced the topic today to you all. The preamble of our constitution begins with the words, "We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens justice, social, economic and political." So the very opening lines in the preamble of our great constitution lays down one of the most significant purpose of our constitution, that is justice. A very good evening to all the esteemed guests. Mr. L. Narasimha Reddy, Senior Advocate, Madam Rashmi Singhania, Advocate, Mugdha Pandey, Advocate, Mr. Guru KRISHNA Kumar, Senior Advocate, Guest of Honor, my esteemed honorable members of the Law Commission, the senior advocates, dear friends. Today we discuss a very interesting topic, the idea of justice after 75 years of independence. All of us often wonder, what is justice? What is this wonderful notion? And what is the concept of justice in today's time? The concept of justice is as old as civilization and society. It is deeply ingrained in the roots of our Indian civilization. The word justice finds its roots in the Latin term justitia, which signifies righteousness or equity. It is also derived from the French word justice, which means uprightness, equity, vindication of right, administration of justice. The idea of justice is most frequently linked to the underlying presumption that justice is synonymous with the idea of equal rights and opportunities and to get fair treatment. Justice is the quality that ensures that each person receives their rightful compensation in opposed to any violation of harm. Justice means to give each and every person what they deserve. Justice means the standard of righteousness. By standard of rightfulness, one means to say that minimum threshold should be applicable of what will amount to right or wrong. Justice can also be understood as the correct application of law as opposed to arbitrariness. A society cannot exist without the presence of justice, which is one of the most important pillars of any nation. Justice can be attained in the society only by correct interpretation and implementation of laws. The perception of the concept of justice may change over time in every society. This can lead to differences in social and fiscal system. My aim today is to focus on philosophical and social interpretation of justice in India and the changes in the definition of justice that have taken place in this society during different periods of time and what justice means in today's date. The idea of justice is so ancient that everything has been said about it, and at the same time it is so modern that it constitutes an ever-changing context of contemporary society. From this perspective, we may say that justice has a traditional meaning and has also acquired a more technical and complex meaning in modern times. Traditionally, justice was seen as a moral virtue of character as well as an important and desirable attribute that a political society requires. For Plato, justice is giving to each person his due. Justice in this sense involves the fair, equal, moral and impartial treatment justice traditionally means ensuring that fair results are produced and each person duly receives what he is entitled to. When we look at the modern view of justice in the context of a legal system, natural justice is built into the legal rules and their observance becomes compulsory in the realization of justice. Justice dispensed in accordance with such legal rules is the legal justice. The law determines what a person is entitled to and also lays down the circumstances in which he can stake his claim to such entitlement. A person so entitled or having a claim to is said to be a right holder. Another who has a corresponding duty to recognize and respect the right of its holder is referred to as the duty bearer. Where the law confers right, justice is achieved when rights are enforced in accordance with law. Where the right of another is not respected, it amounts to violation of rights of the former. In case of violation of his right, the right holder would be caused an injustice. This means that for justice to be realized, the right holder would require a remedy, and this remedy is provided by the courts. Hence, the existence of a remedy is crucial to the enjoyment of a right conferred by the law, as without a remedy, the enjoyment of right becomes meaningless. According to the modern view, justice is about translating the right into action. Thus, we can say that the idea that justice is as a modern obligation or a religious mandate in the ancient times got secularized with the passage of time in the modern period, thereby emphasizing that importance of access to justice in today's date. When we talk about the concept of justice in India, we need to focus on two things. One is the traditional Indian view of justice, and second is the concept of justice enshrined in the Constitution. The concept of justice has also been incorporated into a spiritualist philosophy of Indian thought. To the best of my knowledge, there is no single treatise on the subject of justice per se in traditional Indian literature. However, ideas related directly or indirectly to the justice can be gleaned from the Indian scriptures and other philosophical and spiritual literature depicting Indian thought. The Dharma Shastras include some forms of justice under the rubric and Vyahar. The ancient concept finds justice as a recurring theme in aphorism, quotes in various texts, antidotes, and dialogues. One important feature of the traditional Indian idea of justice that stands out in the predominance of religious code over legal code. That is, if there is a conflict between two legal codes, equity should be supersede law, which means that fairness and equity is given more importance over legality. To understand the idea of justice in today's date, it is important to understand the concept of justice is enshrined in the preamble of Indian Constitution. The framers of Indian Constitution were aware about the need of establishing justice in a country. Therefore, they made sure that it is included in the Indian Constitution. Article 14, 15, 16 and 17 of the Constitution also reflects the idea of justice enshrined in the preamble of the Constitution. All these articles are incorporated under Part 3 of the Constitution, which gives fundamental rights to every citizen. Provisions relating to equal justice and free legal aid are enshrined under Article 39A, which gives every citizen right to get free legal help from officers of the court. No one can be denied access to free legal aid. It is the duty of the state to secure that working of the legal system is based on justice. It should provide equal opportunity and also provide free legal aid to ensure that every opportunity for securing justice is not denied to any citizen due to his economic or other disabilities. One of the important concepts of justice as enshrined in the Constitution is the concept of distributive justice. Distributive justice means fair distribution of resources among those who are in need of it. This has been described in Article 38 and 39 of the Indian Constitution. Natural justice, economic justice, political justice, social justice, and legal justice are a few examples of the many diverse types of justice. Indian Constitution divides three types of justice: social justice, economic justice, and political justice. Now, what is social justice? The social justice as a concept arose during Industrial Revolution of 19th century. Different definitions of social justice is provided by different institutions. For few, it is fair and comprehensive distribution of goods among people for economic growth, and for few, it is equality of status among individuals. Social justice means greater good for larger number of people, and unequals should be treated equally. The Apex Code in Keshwanand Bharti case held that social justice is part of basic structure of the Indian Constitution. Social justice means that equal social opportunities are available to every person for personal development of every person without any discrimination based on race, sex, or caste. No person should be deprived of social conditions necessary for development due to these differences. The concept of social justice is based on the practice of social equality. Social justice can also be enforced in a society where exploitation of men by a man is not present. In the case of S.R. Bommai versus Union of India, the Supreme Court held that social justice and judicial review are two basic features of the Indian Constitution. Now, economic justice. Economic justice is somehow part of social justice itself. The Indian Constitution visualizes socio-economic justice as incorporated under directive principles of state policy. Economic justice means providing economic opportunity, economic equality, and removing economic disabilities. It is always implemented under the umbrella of social justice. Economic justice means there should be economic equality among everyone in the society. There should not exist any inequality among individuals based on their economic status. No one should be deprived of any opportunity due to his or her economic status. Economic status of any person should not be responsible for the lack of opportunities provided to him. Economic justice means eradication of poverty by adding on to national wealth and resources and distributing this wealth equally among everyone who contributes in its production. Now, political justice. The political justice means a system free from political arbitrariness. There should be political fairness in the working of the government. Political status of any person should not give him any advantage. In Raghunath Rao Ganpat Rao versus Union of India, the Supreme Court attempted to provide meaning to term political justice and observed that political justice relates to the principle of rights of the people, that is, right to universal suffrage, right to a democratic form of government, and right to participation in political affairs. In Canara Bank versus V.K. Awasthi, the court highlighted the fundamental premise of natural justice and observed the expressions natural justice and legal justice do not present a watertight classification. It is the substance of justice which is to be secured by both, and whenever legal justice fails to achieve this solemn purpose, natural justice is called in aid of legal justice. Natural justice relieves legal justice from unnecessary grammatical sedentary or logical prevarication. It supplies the omissions of a formulated law. The reference could also be made to State Bank of Patiala and others versus S.K. Sharma, where the court had noted that justice means justice between both the parties. The interest of justice equally demands that guilty should be punished and that technicalities and irregularities which do not occasion failure of justice are not allowed to defeat the ends of justice. Principles of natural justice are but the means to achieve the ends of justice. They cannot be perverted to achieve the very opposite end. That would be a counterproductive exercise. All these types of justice are closely related to each other. One can't be obtained unless and until the other two are present. Social justice can be obtained only when economic and political justice is present. Indian Constitution under Part 3 enforces all three types of justice by making provisions relating to equality under Article 14 and 15. Also in 2019, by 103rd Constitution Amendment, the government has enacted the law to ensure economic justice for everyone. The jurisprudence behind this amendment was implementation of economic justice. The role of judiciary becomes all the more important in our constitution as judiciary is the protector of civil rights and it acts as a custodian of fundamental rights. It plays an important role in enforcement of all three types of justice given under the Indian Constitution. Judiciary has played an important role in the establishment of justice in the country and to make the concept of justice given in preamble a reality. The approach of judiciary has been progressive in this regard and it has shown through its decisions that justice is an essential ingredient of a developed and law-abiding society. In cases like Menka Gandhi, the court has referred the concept of social justice time and again. The role of judiciary has also changed over the years and the courts have taken a more active role in realization of justice through judicial activism. In recent years, courts have risen in power across the world and the Indian Supreme Court has rightly been pointed to as an example of this global trend. In many ways, the Indian court has become a court of good governance that sits in judgment over the rest of the Indian government. The court has been able to expand its mandate as a result of the shortcomings of Indian representative institutions. The Indian Supreme Court's institutional structure has also aided to its rise and it helps explain why the Indian courts have gained more influence than most of other judiciaries in the world. The Indian Supreme Court has been called the most powerful court in the world for its wide jurisdiction, its expansive understanding of its own powers, and the billion plus people under its authority. The doctrine of basic structure was propounded by the Indian judiciary on 24th of April 1973 in Keshwanand Bharti case to put a limitation on the amending power of the parliament so that the basic structure of the basic law of the land cannot be amended in exercise of its constituent power under the constitution. What constitutes basic structure, although not explicitly defined, most of its constituents can be derived from various Supreme Court judgments over the years like supremacy of Constitution of India, rule of law, judicial review, federalism, secularism, fundamental rights, Article 32, balance between fundamental rights and directive principles of the state policy, etc. The basic structure of our constitution is not static but dynamic and continuously evolving. Judicial activism is seen as a success in regularizing access to justice and giving relief to disadvantaged groups because of the efforts of Justice V.R. Krishna Iyer and Justice P.N. Bhagwati. It is an effective tool for upholding the citizens' rights and implementing the constitutional principles when the executive and legislative fail to do so. The shift from locus standi to public interest litigation has made the Indian judicial process more participatory and democratic. The judicial activism therefore counters the opinion that judiciary is a mere spectator. I hope that this will explain the evolution of the concept of justice in this post-independence area. The high courts of the country innovatively interpreted the constitution in a manner as to give effective rights to the citizens which are important in day-to-day life. The framers of the constitution wished to empower citizens with certain rights which are levied as fundamental rights and they cannot be taken away by the government. The judiciary on its part innovatively interpreted the constitution and gave to us various rights like right to information, right to education, right to free legal aid, to include right to life with the dignity in right to life. But we must also understand that judicial activism challenges the concept of separation of power of the three arms of the state. Many times, in the name of judicial activism, judiciary interferes in the administrative domain and ventures into judicial adventurism or overreach. This is when judicial restraint comes into picture. If judges are to be freely given right to frame laws, it would not only go against the principles of separation of power, but it would also result in chaos and uncertainty in the laws. The 5 rights that shaped India, to my understanding, are the substantive equality. India is no stranger to discrimination on the basis of sex. At one point, Air Indian air hostesses were compulsorily retired at the age of 35 or getting married or pregnant. The Supreme Court in the case of Air India versus Nargesh Mirza, AIR 1981, ruled that this represented official arbitrariness and hostile prejudice. Similarly, the criteria for promotion of women, where they are benchmarked with men, shall be same. Otherwise, it is indirectly discriminatory and against substantive equality. Another such example is the decision of the Supreme Court in the case of eligibility of women officers in short service commission in Army for permanent commission. The persistence of the Supreme Court in this case persuaded the armed forces to change their mindset and support equal status for women officers. The second fundamental right shaped by the higher courts is the right to creative expression. The courts in India have developed the law and held that Article 91A of the Constitution of India, which states that all citizens shall have the right to freedom of speech and expression, includes the right to creative expression. The philosophy behind this article lies in the preamble of the Constitution, where a solemn resolve is made to secure to all its citizens liberty of thought and expression. The Supreme Court has recently said that when the ability to portray art in any form is subject to extra constitutional authority, there is a grave danger that fundamental human freedoms will be imperiled by a cloud of opacity and arbitrary state behavior. A declaration attributed to Voltaire, "I despise what you say, but I will defend to the death your right to say," encapsulates the essence of the protection of free speech. I may quote from the landmark judgment of Justice D.Y. Chanchur, as he then was, in the case of Indability Creative Private Limited versus Government of West Bengal, the true purpose of art as manifest in its myriad form is to question and provoke. Art, in an elemental sense, reflects a human urge to question the assumptions on which societal values may be founded. In questioning prevailing social values and popular cultures, every art form seeks to espouse a vision. Underlying the vision of the artist is a desire to find a new meaning for existence. The artist, in an effort to do so, is entitled to the fullest liberty and freedom to critique and criticize. Satire and irony are willing allies of the quest to question, entertain, while at the same time to lead to self-reflection. The third is the right to practice one's religion. The right to freedom of religion, I have been asked to conclude. So, if you people want, I can conclude in because what I was feeling was that this concept of this evolution of the justice in the post-independence period, how the concept of justice has changed, that needs to be explained, and that is why I was going in detail about it. But if the time is short and we have to conclude the program, then I will shorten my preparation of the today's lecture. And I will tell you, actually what I was telling was that only 5 fundamental rights which have been developed by various judgments of the Supreme Court, which are not given in the Constitution, but they have shaped this concept of justice and the delivery of justice system. They are these rights. They are the rights substantive equality, the right to creative expression, the right to practice one's religion, and last, most important, is the right to enforce fundamental rights. These 5 rights, they have in fact contributed in the development of this concept of judicial delivery system and the concept of justice in India. So, we can say that the idea of justice is intricately interlinked with our constitution. Just like our evolving and dynamic constitution, the idea of justice also forever evolving. Rather, it is our evolving idea of justice that derives the evolution of our constitution. We can see example of this in the landmark changes made in our laws in the recent times, like decision of the Supreme Court on right to privacy, Section 377 IPC, 4 personal rights of daughter under Hindu succession, triple talaq, access to internet as a fundamental right, and many more. Thus, we can see that the idea of justice has forever been evolving since the adoption of our constitution. The most general way to understand the idea of justice can be to say that justice is the enforcement of fundamental principles and value enshrined in our constitution. Justice is when a person's fundamental rights are protected. Justice is when the state machinery functions in accordance with the constitutional principles and ethos. Justice is when the constitutional courts uphold the constitutional values. One might also say that to test whether justice has been done or not, one can simply see whether the act conforms to our constitution, its fundamental principles and values. Justice is not mere literal interpretation of the provisions of the constitution in black and white, but it is to understand the aims and objectives of the particular provisions and the principles outlined in our Constitution by our constitutional framers. Our judicial system is the enforcer and protector of justice. In this 76th year of independence, with the society evolving at its most rapid pace, we have to focus towards the goal of a welfare state. The directive principles of state policy contained in Part 4 of the Constitution set out the aim and objective to be taken by the state. The idea of welfare state and the Constitution can only be achieved if the state endeavors to implement them with a high sense of moral duty. We should strive to promote welfare of the people by securing and protecting a social order in which justice, social, economic and political shall inform all the institutions of national life. In the celebrated case of Keshwanand Bharti, the Supreme Court has said the fundamental rights and directive principles aim at the same goal of bringing about a social revolution and establishment of welfare state, and they can be interpreted and applied together, and that they are supplementary and complementary to each other. With these thoughts, I conclude my views on today's topic, and I congratulate all the organizers of this successful event and also thank them for inviting me to share my thoughts. Thank you. Jai Hind.